Thank you. Mr. Grossman, when Congress passes a law instructing an agency to act, in some cases special interest groups sue those agencies and then obtain consent decrees that override Congress by requiring agency rulemaking favorable to the special interest. Doing so can bind the agency in ways not intended by Congress and even in ways that then bind subsequent administrations. But there's also another problem associated with this particular paradigm known as the Equal Access to Justice Act. Have you ever heard of the EAJA?
Yes.
Can you briefly explain what the EAJA does?
Well, in general, a plaintiffs group that obtains such a result in a case would be a prevailing party and so would be able to recoup a large amount of its litigation costs, including attorney's fees.
Well, and that's if there's litigation, but they also, the agencies and the environmental groups can actually enter into a consent decree where the agency will agree to pay EAJA funds to particular environmental organizations. Is that right?
Yes.
So I'm going to read a bit of information to give the folks here a bit more background about how the EAJA has been abused over the years. Environmental litigation has become an expensive national policy issue that causes harmful gridlock for the federal agencies managing wildlife and public lands. At the center of the problem is the Equal Access to Justice Act, which permits the recovery of attorney's fees in lawsuits against the federal government. EAJA was enacted in 1980 to protect ordinary citizens and small business from government overreach and wrongdoing by giving them the means to pursue otherwise prohibitively expensive litigation. Over the years, EAJA has shifted from being a well-intentioned corrective measure to a powerful weapon for large, well-funded special interest nonprofit groups to continuously sue the government on environmental issues. Litigation against government agencies is virtually nonstop because these groups can recover substantial legal fees under EAJA, even if they win only a small part of the case or settle out of court. Most of these lawsuits are settled out of court. And recently, I filed a bill to delist the grizzly bear. But one of the things that happened was that the Fish and Wildlife Service agreed in 2007 and again in 2017 that the grizzly bear had been fully recovered. Environmental groups sued, and eventually the Fish and Wildlife Service reached an agreement. When the environmental groups came back seeking funds, they sought almost $500 an hour in their legal fees, and ultimately $1.4 million under the Equal Access to Justice Act. Wouldn't you agree that that is another incentive or perverse incentive that has been created that needs to be fixed, that encourages these kinds of sue and settle tactics that you're describing?
It is a very unfortunate structure in that effectively it's a self-perpetuating pro-regulatory, almost lobbying treadmill. Because groups sue agencies to compel agency action. If in many instances the agency will be favorable to what it is the group is asking for, and so they then get priority for their policy preferences, and at the same time, they obtain additional funds that they can use to promote further regulatory initiatives. It is a very unusual structure that you would have the government funding effectively a pro-regulatory force to force the government to undertake additional regulatory actions. It's not protecting people's rights against the government, it's expanding the government to exert more force in general.
Interestingly enough, I've had numerous opportunities to deal with EAJA as a trial attorney, and I have worked with a variety of organizations, private landowners, farmers, ranchers, irrigation districts, interest groups such as Farm Bureau, stock growers, and those kinds of things. What I have found is when I prevail against the federal government, it's very difficult for me to receive EAJA funds. And yet, when environmental groups, again, may prevail on a technical matter, and the agencies will actually enter into consent decrees so that they can get the EAJA funds. Have you noticed a similar pattern in what you have reviewed?
It's simply another aspect of the collusion that is unfortunately prevalent in the space, and certainly something that I think demands Congress's attention.
Thank you, and I yield back.